Good afternoon to everyone that's participating in the Small Firm Exchange presentation today by John Becker. It's my honor and privilege to introduce John. He's been defending claims against design professionals and drafting negotiated contracts for his clients for the past 35 years. He is the founder of Thompson Becker LLC, a trusted firm with nearly 30 years of experience representing architects, engineers, land surveyors, and construction professionals. And on a personal note, John has been our firm's attorney for the past 16 years. He's very skilled, and he has guided us through mentoring us through contracts and how to deal with some of the sticky things with clients in a way that's been very positive in the outcome. And I have a tremendous amount of respect for him, for his soft skills and his knowledge. So without further ado, here's John Becker.
Thank you, Marvin. Thank you for the kind words. Now the pressure's on. I have to deliver, right? Okay. I can't see everybody. This is something I normally do live. So everybody who is watching remotely, please bear with me. We're going to talk today about some basics regarding contracts and the standard of care, and specifically their importance to the bottom line of your business. After all, you're all professionals out there. However, there is a business side to the practice. I'm sure that if I asked for a raise of hands of how many architects were doing this as a hobby, nobody would put their hands up. But after my several decades of experience, I've come to learn that with a little bit more attention to the contracts and understanding the standard of care, firms can eliminate, if not mitigate, a lot of risk. And by doing so, you improve your bottom line and you make some money. And I'm sure, after all, that's what you're in business to do. So the first concept we're going to talk about is the standard of care. And after doing this, again, for quite a while, I've handled thousands of claims and worked with hundreds of architects. And the thing I see most often is they don't understand the legal standard by which they are judged on the adequacy or the quality of their services, and thus whether they are liable or not to customers or third parties. So generally speaking, the standard of care for all design professionals and other professionals such as lawyers and doctors is to perform in a manner consistent with the ordinary practitioner. Okay, so essentially what that means is there is no such thing as being a perfect architect. There is no legal standard for being the best or a top tier or anything other than the ordinary architect. That's the level you will be judged with when you provide services. And this applies, of course, whether or not you have it in a contract form, such as exists in the AIA, or not. In New Jersey, where I practice for the most part, if an architect is going to get sued for malpractice or professional negligence, whatever you want to call it, and you're going to show up in court and ultimately be tried, the model jury charge, as you can see in the third bullet point here, is going to be the language is almost identical to the language in the first bullet point. The architect has to use that degree of knowledge, judgment, ordinarily possessed by the average architect. Okay, so the bar for legal liability is average or ordinary. The law does not expect or require perfection. That's something to keep in mind, because a lot of customers, whether and I'll interchange customers with owners as we go. A lot of your customers expect perfection, and that's an unreasonable expectation on behalf of customers, which is why it is good in your contracts to include a standard of care provision that will manage that expectation, right? The AIA, you're all members of the AIA, and if you're not using in some way, shape, or form AIA forms of agreement, modified as needed with the help of counsel or your own experience, if you're not using them or using that language in some sort of template, your own private form or template, you're doing yourself a disservice. And you can see here that the AIA and the B101, which is the owner architect agreement flagship document, you'll see the ordinary language appearing in the first line. And there's a second line there that talks about not just that level, but the timing of your services. In other words, your services can only be performed as expeditiously as is consistent with the standard of care and the orderly progress of the project. So it's difficult to tell your client you're going to hit an exact deadline because there are so many variables and circumstances that could impact that delivery. The law also does not request or require you to be with pinpoint accuracy on schedules. And again, owners don't like to hear that. I understand that. But the language here is to your benefit, and you should try to keep it at all times. Some of you folks may have engineering components or practices in your business. And if you're familiar with the Engineers Joint Contract Document Committee, that's the conglomeration of the various engineering associations. They produce documents as well, similar to the AIA documents. And they, at the end of their document, underlined here, they disclaim warranties, which is something that is very important because a warranty is essentially a guarantee of compliance, perfection, quality, and it's contrasted to and departs from the standard of care. You do not want to give warranties anywhere in your contracts. You don't want to verbally tell your client you are going to deliver a perfect project or warrant that you won't make mistakes. And there's a good reason for that. Not only does it depart from the law, and you are now assuming a liability greater than what the law obligates you to do, you are going to run afoul of your professional liability insurance carrier because they do not cover warranties. So stay away from that. And if you're going to use this AIA language, as we discussed, I would borrow this last sentence from the EJCDC and plop it in at the end. Now, a lot of owners, and I know this through experience with negotiating, again, thousands of contracts with owners and their attorneys, they have a hard time differentiating contractually between architects and contractors. Whereas contractors issue warranties for their work, the owners expect to see that same thing from design professionals. They don't understand the difference in the two types of either service or work providers, and you need to be able to educate the owner and their attorneys and explain to them that you don't give warranties. Now, you might say, should I care about the standard of care? Why is that really important? And besides bringing your contracts into compliance with the law, bringing your services and the expectations of your customers into compliance with the law, you should know, and it's no secret, that architects and other design professionals are generally at high risk for claims by disgruntled owners, disgruntled contractors on projects, and often third parties, members of the public who may encounter a project you designed, maybe trip on a set of stairs or something of the like. And statistics show us, and this is an old statistic, but still it's relevant. I don't think if I brought it up to date or this organization that prepared it brought it up to date that it would be much different. Architects are at high risk. This is a claims frequency chart. That means how many claims as opposed to how severe or how bad they are. And you can see architects were at 41% of claims over an almost 10-year period. And that's a sizable margin. Now, when you talk about the severity of claims, that is, how bad are they? How much money was paid out? how much was the claim amounting to. I was just checking at Ames and Golf and their 2025 market survey, and mechanical engineers, structural engineers, and architects were running neck and neck with severity, which means, again, how much is being paid out on a claim basis as opposed to how many claims or how frequent the claims are. And civil engineers were leading the pack. So keep in mind that owners and their attorneys are aware that you have the policy of insurance, and while it is necessary to protect your practice, they treat it sometimes as something that they can plunder, and they will, make an architect a party into a case, whether or not, at least in my experience, there is always merit to that claim. Now, what is the standard of care? We looked at the language. It seemed kind of vague. Architect will provide services consistent with professional skill and care ordinarily exercised by members of the same, profession in the same locality, same type of project. It seems kind of vague, right? Well, it is. It's a legal standard. It has to accommodate just probably millions of scenarios of potential liability. So we know the legal concept. We know how it's phrased. How is it interpreted and how is it enforced are a whole nother series of issues that we can address. And here we have some examples of what sort of documents, what sort of information goes into establishing the standard of care if you're in a court case. One of them, of course, is contracts. There are contract provisions that talk about the right to rely upon the accuracy of information provided by the owner. There are contract provisions that talk about your responsibilities during site visits, during submittal reviews. It goes on and on. Contracts can help establish the standard of care beyond just the formula for the standard itself. There also are building codes, right? Just because, though, you design something to a code minimum does not mean that you've complied with the standard of care. It's a good start. It may be dispositive on a certain issue. But for example, if you are an architect designing luxury condominiums, you're not going to design sound attenuation between those units to the code minimum, right? So building codes and zoning ordinances provide a basis. Sometimes they do establish a standard, sometimes they do not. There are professional publications and promulgations, of course, from the AIA. They have all sorts of practice pointers. They have all sorts of good information on their website and available to their members. And in fact, in New Jersey, the courts have looked at the AIA as being authoritative, and courts will often take judicial notice of what the AIA promulgates. There are other treatises and articles that people write, books and books and books by authorities on various topics, of course, case law. And what usually happens, in my experience, is the consensus of the industry. And what does that mean? I've tried to describe it as follows. If I took 10 architects and I said, under this circumstance, I'm going to give you some facts. Tell me what you think the ordinary architect would have done. If I get 7 or 8 or more architects agreeing on what should have been done, that could be considered the consensus of the profession regarding the standard of care. So you have a standard of care, and somebody brings a claim. Let's talk a little bit about the concepts of mistakes versus negligence. So a violation of the standard of care is negligence, but a mistake is not necessarily a violation of the standard of care and therefore not negligence. So mistakes can be made. In fact, there is plenty of literature out there that indicates a simple mistake, whether it results in a change order or not, is not per se negligence. And despite the best efforts of all architects, it's very difficult and therefore not expected by the law that you will have a perfect set of construction documents, especially if the owner wants their construction documents fast. They don't want to pay a lot of money, and they don't want to go through numerous peer reviews and so on and so forth. So the question of who pays for mistakes that result in is what are considered, again, and they should be anticipated and should be considered unavoidable design errors and omissions, is of interest to the community, and something which I've been involved in defending, again, for several decades. There are typically two different types of mistakes: an omission and an error. And it's important to know the difference because they have far different ramifications. Omissions are elements of the design at the time the contract is bid upon and awarded that were not present in the documents. The easiest example, of course, would be missing windows. There was no window schedule. For whatever reason, the architect, in getting out the construction documents, forgot to put a window schedule. And for whatever reason, the contractor didn't bring that to the attention to anybody. And let's just assume they bid it without noticing the windows were missing. But when it comes time to close in the building and all of a sudden somebody realizes the windows are missing, that now results in a change order to specify and procure windows, right? They were omitted. That is an omission change order. And when discovered, and when you think about it, those windows, those omitted items, when put back into the project, they add value, right? I mean, the building needs the windows. The owner would have paid for windows if they had been included in the design to begin with. Now, you can do this thought exercise with any number of things. I'm just using a simple one with windows. It could be missing insulation. It could be missing electrical wiring. It could be a missing rooftop unit, so on and so on and so on. But the owners oftentimes turn around to the architect and their sub-consulting engineers and say, well, you have to pay for this. And what I'm here to tell you is that is not true. That's not accurate. That does not reflect the standard of care, and that does not reflect the law. Those omissions, if they would have those omitted items, those omission change orders, if they would have been paid for by the owner, had they been included in the bid documents, constitute what we call betterment, right? It's what I've learned in law school, the fancy legal Latin phrase is you don't get shit for free. So keep that in mind when you're dealing with owners who are putting change orders in front of you, and they want you to pay for things they would have paid for had they been in the contract documents. You can also include a betterment provision, and there is a sample one offered by the AIA, and you can put it into your contract, and I do that for my clients. Now, errors are a whole nother story. They hit a little bit harder because they're mistakes. They're not things that just were forgotten and overlooked. They're actually mistakes, conflicts, ambiguities, things of that nature. And they hit a little harder for an owner. And when corrected, they usually don't add value. You're just like trying to bring the documents into either coordinating them with your subs, fixing a model number on a piece of equipment, resolving a conflict, in a ceiling space, or an undersized structural member, whatever. Mistakes happen, and the facts of that specific mistake, and if it results in a change order, varies. And we can do an entire seminar on that about whether or not they get paid for by the owner, the architect, or sometimes even the contractor. So part of the reason that the architect may not have to pay for errors has to do, again, with the standard of care and what we call the safe harbor and the interrelationship of the contingency. Basically, if your plans don't have to be perfect, there has to be some way to articulate in a quantitative fashion what is the level of accuracy you have to hit to satisfy the standard of care. And for new construction, ground up, maybe in a field, something's not too complicated. The authority is basically that you have to hit 95%, which correlates to you have an anticipated 5% of the construction cost that will be made up in the form of change orders. And this is very difficult to explain to some owners, but the sophisticated ones understand what I'm talking about. And that's why they carry contingencies on their projects, because they know from experience that once construction starts, that last 5% or so of the design is going to get worked out in the field. Could be some conflicts, there could be some issues, we'll get it resolved. And when those change orders come in, if they're less than, in this hypothetical, 5%, then that's the safe harbor and there's no liability. So try explaining that to unsophisticated owners. It's often difficult at the time it happens. It's much better to try to get that discussion happening prior to contracting or as part of your ongoing relationship with your customer. Now, I know that through practice that architects are reluctant to discuss this concept of a safe harbor, or sometimes reluctant to try to put contract provisions in to manage the expectations of their customer. But I would ask that you consider it. You can start it on a project by project basis or a customer by customer basis. But once you are able to enforce this legal concept and manage the expectations of your client, I think that you'll find much greater success in your practice. I often tell the groups that I speak before that having such a large sample size of claims over the years, that one in four claims really have to do with a single event, like a incorrect calculation that has a catastrophic loss, or a code violation that has a catastrophic loss. Most of the claims, 75% of them, have to do with failures to communicate during a project. And part of that has to do with what we're talking about right now. Having that upfront, frank conversation with your counterparts on the standard of care and the contingency and the safe harbor, especially as change orders start to arise on a project in the beginning. The sooner you would address a change order, as soon as you push back on an owner or their construction manager saying it's your responsibility, the sooner you introduce the concept of the safe harbor with an owner, the better. And I see more of these change orders and cost overrun claims than I do the more traditional design defects. So I think this warrants some time and attention in your practice to, again, promote your profitability. So for example, if you're handed a change order because of an error at the beginning of the project, you don't pay it, and you also should not accept any set off from your payments. In fact, the AIA has a section, I think it's 11.10.2 in the B101, that precludes the owner from setting off or withholding payment based upon potential change order claims. So this is not the gospel according to John. This is the gospel according to the AIA. Marvin, were there any questions on this topic before we move on? Because
John, there is. There's a very good question from Robin Andrade. What about contingency for renovations? I mostly have renovation projects and always find that the contingency varies a lot.
Sure. In general, renovations, alterations, additions, anything dealing with existing conditions is going to have a higher safe harbor. So let's say, in my experience, and it varies between 7-13%, depending upon the project. Again, this is something for you and other design professionals, such as experts, to establish it if there's a lawsuit, in a claim situation, or in discussions with your customer about advice on setting a contingency. You want to try to, of course, get that as high as you can based on experience with other projects and so on and so forth. But 7 to 9, more complicated, 7 to 13%. Without a doubt, I try to hit a solid 10% on a recommended contingency to an owner on a renovation project. I also will say, at the risk of running out of time on the back end, that having dealt with this so often over time, that I've now been working with clients on recommending, strongly recommending on any existing condition project that the owner invest a little bit of money in some testing, inspection, whether it requires ports or destructive, invasive type stuff, that they spend a little bit of money up front so you as the architect and your subconsultants can understand what is behind walls, what is above ceilings, all for the purpose of getting more accurate design documents prepared and troubleshooting problems that can be handled in the design phase and early construction phase, as opposed to exposing a wall and all of a sudden finding something behind that nobody was expecting. You know, maybe there's a stone instead of steel, or steel instead of stone, whatever. Trying to do those early investigations, you get paid to do it. And I've been hearing some good things that a lot of stuff is getting taken care of early, as opposed to what I think the standard is. You say to the owner, I'm going to design based upon what I can see, and you as the owner have to understand and take responsibility if there's going to be added cost due to unforeseen conditions. That seems to be the standard. I'm trying to push people to be more proactive and eliminate the surprises actually during construction. So I hope that helped a little bit. Any questions that we don't get to today, any questions that you may have, I think my email address is available through Marvin and the AIA. If not, I'll ask if they give that to you, and you can send questions, and I'll be happy to discuss those with you. So now we're going to move on out of the standard of care into the role of contracts on a project, right? What are they? I mean, they just define the relationships, right? The legal responsibilities, the roles, the standard of care, scope, payment, all that good stuff. And it's good to have some sort of a contract with the client. You know, anything is better than nothing, in my opinion, especially if you get the stuff in there like the standard of care, you disclaim warranties, maybe you put in a betterment provision, so on and so forth. They need to be written clearly, and they have to be understandable by lay people, by non-lawyers, by even non-architects. So if you're using a lot of architectural jargon, you're using a lot of legal jargon, the better you can get it, you know, I say an 8th grade level sometimes, to the extent possible, the more you have a chance of getting them enforceable. And of course, they allocate risk, they mitigate risk. If you're not going to get paid, if somebody fails to pay you, having a contract provision that says failure to payment allows me to suspend services. Failure to payment allows me to terminate. That's all good stuff. Using the standard forms of the AIA or the EJCDC are good for consistency and uniformity, but I want to say that you should not, I don't think, under any circumstance, take an AIA form off of a shelf and use it without any modification. In fact, the AIA warns you against that in their own commentaries and document. They have like some explanation along with each set, and explain you know, why they are putting certain provisions in. They tell you their documents are there to help and assist. They're there to be modified and edited to suit your unique circumstances. In fact, I have a standard B101 template where I probably have about a dozen to 15 standard modifications based upon my experience over the years, where I've like added, for example, the warranty disclaimer, I've added betterment, and so on and so forth. So they're very good. I, of course, am a big proponent of the AIA, and you have to know, though, that they do not think their stuff is off the shelf, plug and play, and move on. Custom agreements. I do those as well. They are probably used more often than the AIA, and there's nothing wrong with that. There are always standard provisions, certain core things that should be put in there. You've got to clearly establish your scope of services. You've got to clearly talk about your fee, sometimes schedule, and of course the legal terms and conditions. They're the three sections I see in almost every agreement. And as long as you are getting the good stuff in there that's needed, and to the extent possible, using some of the same terminology and language as the AIA, then fine. Whatever form of agreement you use, as long as it is clear, understandable, enforceable, is okay by me. Let's talk a little bit about professional liability coverage in general, because it often shows up in contracts, and I've mentioned it a few times now. There's going to be, I think, in the audience, there's a broker. Rich Standing is in attendance, and he will be doing a seminar in more detail on professional liability coverage. So I'm going to cover it in general. He will be doing it in greater detail, and I encourage you to attend that. But your professional liability insurance is super important for your practice. If you are practicing architecture, you don't have professional liability coverage, I'd advise you to get some. And if you say, well, I've been in practice for 10, 20 years, I've never had a claim, I've heard that a bunch of times. And the person comes into my office without coverage because now they have a claim. So it's like everything: health insurance, auto insurance, homeowners insurance. But in your profession, if you don't have it, I think you're doing yourself a disservice and a great risk. It's distinguished from your general liability. So they sometimes call it commercial general liability, CGL, whatever. Your general liability insurance, as far as I'm concerned, having represented design professionals all this time, doesn't mean squat. It just does not apply to the rendition of your professional services. There is going to be an exclusion or an endorsement that will say so. General liability carriers do not defend claims brought against architects, with some very minor exceptions that don't last very long, depending upon what jurisdiction you're in and how that state's law interprets coverage based upon the actual lawsuit. But do not think that you're going to be protected by GL insurance, especially since it looks so much cheaper than your PL insurance. The good thing about your PL coverage is going to cover everything caused by negligence. They call it the change order, the code violation, worker injury. There's almost nothing it does not cover, except for a fee dispute with your client. It's going to provide you with the defense of an attorney who does mostly nothing but represent architects and engineers. So the insurance carriers who cover you have panel counsel. Me and my firm work on for almost every insurance company that I can think of, and they're going to defend you, and they're going to indemnify you, which means pay for losses that are covered by the policy. What won't be covered by the policy? If you have a contract that says you warrant the outcome of your services, that's going to be excluded. So tying together some of the contract principles we talked about earlier and the insurance policy.
Hey, John, we have another question about insurance.
So add the frequently asked.
It's from Allison Adderley. Do you recommend architects licensed within a firm carry their own E&O insurance in addition to what the firm provides?
No, and I'm not even sure if you can get any. You'd have to have your own business, or I guess be a sole proprietor. But if you're a firm, if you're a licensed architect or even an employee of an architectural firm, you're covered under their policy. If you have your own side business, you're doing anything off on the side, then you should then consider getting your own policy. That might be a good thing for Rich to discuss in his seminar, but I've never seen an employee of a firm have their own policy unless it's for their own side business. Now, having said that, and this is probably beyond the scope of this seminar, there could be instances where especially a licensee who signs and seals but is not an owner could be subject to claims after their firm closes down, goes bankrupt, or discontinues coverage. So that is a legitimate concern, and I'm not sure if the market even provides for any sort of protection in that situation. And again, if Rich is listening and has time to address that when he gives his presentation, I think will be helpful. Or of course, Allison, you could contact me for a greater discussion. Okay, so risk management, protecting your fee. This is the good part of the good, the bad, and the ugly. You want to make money after all, as we said earlier in this, in my opening. Nobody here is doing this as a hobby. So why do you want to expose yourself to non-payment? As a wise attorney told me when I was a young attorney, he said, John, I'd rather not work and not get paid than do the work and not get paid. And I think that should transfer over to you folks as well. One thing that your contract should absolutely have is an attorney fee collection provision. This will allow you, in the event an owner does not pay you, and you could prove that that payment was that non-payment was improper, or that you are entitled to the payment, you can collect your reasonable amount of attorney fees and costs, et cetera, for chasing that owner. So I see this all the time, and I'll kind of hit some points real quick. Let me see if the next slide is going to. Okay, nope. So this is a good point here. First of all, get your contract signed. If you have an attorney fee provision, you send it out to your customer. They don't sign your contract. Well, you might as well not have a contract. That's the number one problem. People come into my office. I'm owed 30, 40, 50, $100,000. Here's my contract. It's not signed. I grind my teeth. Why isn't your contract signed? I've heard all the excuses. None of them make any sense to me. At the very least, set somebody up in your office that when your first bill goes out, have that person check and see that there is a signed contract in the file. If there's not a signed contract, you get it signed like right then and there. You never wait. You have to get your contract signed. That's number one. Number two, start trying to get retainers, right? I know some clients do no projects without retainers, and I know some clients do all projects without retainers. So get a retainer, and then my recommendation is to always put in your contract that the retainer will be applied to the last invoice. So that's your money. You're holding their money at the end, so that when the job's done, you can pay that. You pay the final bill out of the retainer. You refund them any difference, and that way, hopefully, the owner does not get too far ahead of you or ahead of you at all with unpaid invoices. If they squawk and they don't want to give you a retainer, think about whether or not that client really is a good client for you or not. This is, a huge problem, and don't let them get too far ahead of you. Suspend services if they're not paying you after, the first 30, 60, 90 days, or it's too much money enough. Just suspend services. You have that provision in your contract. And then, of course, you have the attorney fee provision to seek to get paid. Because my experience tells me we had a $6,000 claim, non-payment claim, a collection complaint recently for a client. $6,000. They got stiffed at the end of the job. They did not have a signed contract with an attorney fee provision. I told the client after they were offered half of that, and they rejected it. They wanted their full amount. It was going to cost $7,000 or more to try the case. They said they don't care. We tried the case. We collected the $6,000 and we sent them a bill for $7,500. You can see how that doesn't make a lot of sense to a lot of people. It did to that client. They're an outlier. But if they would have had the attorney fee provision, it changes everything. Leverage changes everything. Okay. What else?
Hey, John, there's
Yes.
Three more questions. So this is from Jim Spinola. Can a sole proprietor contractually limit their liability to the contract?
You can limit your liability to anybody that you're in privity of contract with. So I actually may have a limitation liability clause coming up. what I always seek to put that in contracts for my clients. It doesn't matter if you're a sole proprietor, an LLC, an Inc., a PA, a PC, a partnership. Doesn't matter. You can limit your liability. However, the limitation clause has to be compliant with public policy, which means you can't limit to the amount of your fee. You have to have a certain limitation in proportion to your fee that the court does not find offensive. In other words, the court wants to see that you have disincentive to perform poorly or incentive to perform properly. You got to have some skin in the game. I use a 5% multiplier of the fee in my limitation of liability clauses as the basement floor. About the closest I'll get to limiting liability is about 5 times the amount of the fee. Ownership.
Like, so you have a history and you're pulling from that history and now
John, I'm sorry.
Sure.
We had a couple more related ones. Ricardo Suarez says, is there any reason to carry GL? Example, I run over the neighbor's dog while visiting a job site.
Okay,
no
that
commercial.
That should be auto, and yes, you should have your GL as well, because that covers way more. I think we've got an open mic. Is that you, Marvin?
That's me.
Okay, so you should also carry GL, so you should get a good broker, a good PL broker, maybe a separate GL workers' comp broker, but you can find somebody who does both. That's best. GL will do a lot of things for your business, like premises liability and things like that. It's not a substitute for PL, but it does have its place. The first case I heard of GL actually coming into play for an architect, they had a trailer on the site. Somebody walked up their trailer steps, tripped and fell on the trailer steps. That's a GL claim. But it just doesn't, GL does not give you the coverage for your professional services, similar to how owners think and understand that GL will cover damages due to accidents on a work site for a contractor, right? Like a collapsed scaffolding resulting in damages, or a wall falls over and crushes something. That's kind of GL stuff for contractors that owners mistakenly think architects also can use. Was there another question, or should we move to
there's really quick 2 ones. How do retainers work for public projects?
Say again? How do retainers work for public projects?
Yeah, this is from Stephanie Deutsch. How do retainers work for public projects?
I'm unaware of any law against retainers for public entities. They may be less willing to issue them, as most public bodies are, to do anything that a private customer can do. Is much more flexibility. So I don't recall there ever being anything that precludes retainers. So if you're working for a municipality or a planning board or a county, you can seek to get your retainer, see what they say, what reasons they give you. It should be a matter of negotiation.
And we have one more about retainers from Robin Androdny. Retainer, I credit partial retainers after CDs and then credit partial during construction administration, the last few invoices. Do you recommend against this?
Well, if it's been working for you, fine. Maybe if you know, every customer and client is different. I prefer that the retainer be saved until the last invoice. If you're getting into that part of construction where you're nearing completion and you think that your fees are well within the retainer and you want to start drawing down from the retainer from the third to the last, the second to the last, and then finally the last, feel free to do so. If you're working with a client where your system is working now, that's great. But my experience is that if you have the retainer there at the end, they can't stiff you for that last $500, that last $1,000, that last $1,500 invoice. But do what works for you. It's difficult to get retainers out of clients now, so I consider it an absolute benefit to do so. And again, I prefer to save it to the end. But there's no wrong answer. Okay, ownership. Do this one quickly. You own your documents by law. You license them to the owner, and that license is contingent upon prompt payment of all sums when due. So if they don't pay you, then you can say, I'm going to suspend or I'm going to terminate, and that should then break the license. A lot of owners don't like this anymore. They're asking for ownership of your documents. I then, in talking to my clients, usually revert to the position of you only get ownership at the end of the project after you paid us in full. So that's the quick approach to instruments of service and ownership of documents. It's a very complicated topic. Could be its own seminar in and of itself. Let's see here. There are two provisions here that I use sometimes to get paid when the client or customer isn't paying. So in other words, we basically say that we got a deliverable schedule, and if you don't pay us, and if there's a balance due when time to turn over documents, we're not going to do so until you pay us. And this also then through this section here, whoops, you tell I'm a novice at this. You can see the last sentence here, and then in the other one, it relieves you of liability for any delay damages that the owner may squawk about by not getting their documents, because you're basically saying, I'm losing the ability to collect, my money from you, and you haven't paid me. You owe me 3-4 invoices. Now you want me to give you the plans and specs? How about you pay me first? So I think this could be useful and helpful in a lot of situations. And you can, of course, swap out engineer to architect here if you want to borrow this clause. Additional services. Let's talk about that real quick. These are two AIA sections. It's their policy that you and the owner should be putting any additional services in writing before they are performed, sometimes indicating that you're not going to get paid if you don't do so. And I see this all the time. I'll get the collection case comes in. Here's 3 invoices for basic services, and then here's an invoice for additional services. I look at the contract that says you need to get it in writing before you proceed, so you guys are all on the same page with scope and fee and all that kind of good stuff. And I find out that they being my client, did not get the additional services, which is essentially a fee modification in writing. And now you have somebody new with the ownership. It's not the same PM, it's a different person, and they're disavowing it. They know nothing about it, and they're using the contract that you agreed upon to bar you from getting paid. So be very careful with additional services. Nowadays, with cell phones, with emails, text messaging, at least if you don't do it in a formal kind of change order or contract modification or amendment format, do it with email, do it with text messages, which I don't think you should be using at all, but rather use it and have some proof that you were authorized to do additional services for X dollars in order to get paid.
John, we're toggling back to ownership.
Sure.
We have a question from Joshua Zender. What about copyrights? I have a client wanting me to give my copyrights as qualification of a submission. Do I let it go, or do architects accept that? Question.
It's negotiable. Copyright is just simply what the federal law recognizes. An architect has a copyright interest in its instruments of service, which is essentially intellectual property. And if you register your design with the Copyright Office, you then can enforce infringement, and with enhanced penalties. I recommend that you copyright all of your designs. But if owners are asking you to give up ownership, including copyright, that's a negotiation, and you have to decide what to do. So I know in Marvin's business, he does some, what I consider to be, some pretty nice custom residential with some very interesting aesthetic qualities, and he wants to preserve that design and not have an owner take it or a builder take it and redesign it next county over, next town over, that kind of stuff. So he protects his intellectual property and his copyright. In the situation of the questioner, it all depends on your business risk and your leverage with your customer. They can't force you to give them a copyright or ownership of the documents, but they may not give you the job. If they're asking after the fact for you to do it, then you need to talk to somebody about the appropriate releases to do that and whether you're entitled to compensation. Very complicated again, and sorry, just not within the scope of this basic presentation. Here are a couple other things that will help get you paid. Of course, we talked about the importance of signing the agreement, how important it is. I want to talk about a concept called mirroring. So you as an architect, if you're going to hire an engineer subconsultant of any sort, MEP, structural, civil, if you have them under, it doesn't matter, lighting design, whatever. You never sign your engineer's agreements. The AIA, in its wisdom, understands that the obligations that you have with the owner, let's call it the prime agreement, could be a B101, could be your custom, you have to flow down to your subs all of your responsibilities and liabilities with the owner. So if you have to arbitrate with the owner, then your subs have to assume that arbitration obligation with you and the owner. Your contract with your subs has to mirror your contract with the owner so that you don't get stuck. Never, ever sign an engineer's proposal with terms and conditions. In the AIA, there's a C401 that takes care of the flow down and the mirroring. You can mimic that in your custom agreements. It will save you tons of heartache and problems in the future from a engineer squawking about non-payment, wanting to suspend, wanting to terminate, not giving up their documents, whatever. That all has to be bound up in your agreement with them so that they are subject to the same obligations and responsibilities that you as the architect is subject to the owner. Pay on pay clause for subs, I put that in there, even though it's not in the C401, that you will pay the subs when and if you get paid by the owner. They don't like that, but you're bringing the work to them, and I usually don't have any problems getting that. Construction liens, not as prevalent as you might think. If you're doing residential work, you almost have no time to file a construction lien. The law requires in New Jersey that they be filed within 90 days of the last date of service. You have to have a written signed contract with the owner. And residential, you have to start a process called a nub. You have to do a little arbitration that you got to start within 30 days in order to get permission to file the lien within 90 days. So it's almost unusable for residential work. For non-residential, 90 days from the date of the last service to get paid. I would use those, but you have to do it perfectly under the construction lien law. They do not tolerate improper liens. There's a lot of penalties. Okay, not reducing risk, not reducing exposure, failing to take the opportunity to mitigate loss and reduce exposure is just bad. We got a waiver of subrogation. That's in the AIA, and that essentially stops an owner's insurance company from suing you after it's paid out to the owner for a loss. So let's say there's a fire during construction. The owner has coverage, premises liability. They pay for the loss. Then what happens is the carrier looks around for who to recover against, who caused the fire, who's responsible. In my experience, they often take a shotgun approach, and I have clients sued all the time by insurance companies on behalf of owners, sometimes contractors, looking to subrogate and collect, recover their payments. This waiver, if you have it in your contract, stops that in its tracks. And I love writing those letters to those insurance company attorneys saying, leave my client alone. More importantly, I think, is waiver of consequential damages. This is not, again, one of those easy legal concepts to understand, but let's see what we can do. If you are at fault, if you're negligent and you have damaged your client, let's say the owner, there are two types of damages: direct damages and consequential damages. Direct damages would be the costs that those expenses, those costs that are directly related to the actual negligence of the architect. So for example, if you did really bad, you missed a code and some of the work had to be redone, well, that's a direct result. Refinishing the work, hiring a new architect, these things that are closely related to the actual fault of the architect or direct damages. On the other hand, if that same mistake led to some faulty work that had to be replaced and it delayed the opening of the project, as a consequence of that, the owner may say that it now has longer carrying costs and interest payments on a loan. It may claim business interruption or lost rents. These can be waived by contract. And it's the AIA's position, and they have this clause in their documents, and it's my position that this is very, very helpful to get because it kind of confines, let's say, less than ethical attorneys sometimes and claimants from expanding the list of damages, the consequential damages to the nth degree. We lost the business rent here, and that means we then invested in this stock fund, so we lost the use of the money, the opportunity cost there, and then I had to fire 2 people I pre-hired, and then they sued me, and now I want you to pay for that lawsuit, and it just goes on and on and on. And consequential damages dwarf oftentimes the actual direct damages. So owners don't like this. It's very difficult to convince them to give it up, but nothing ventured, nothing gained. I just did a contract this morning before I got on the seminar here, and the owner made a lot of edits to my contract, but they did not cross out waiver for consequential damages. So that's great for that client going forward. Here's limitation of liability. I thought it was going to be here. Here's a clause that I use, and you can see down here. Oops, there I go again, trying to touch the screen. Here you can see in this font that's slightly different colored, where we say all the claims against the architect shall not exceed the lesser amount of either 5 times the fees paid or available limits of PL insurance. So this way, we have a self-executing provision. So if you have a $50,000 fee, this would mean that your liability does not exceed $250,000. If you have $1 million policy, though it's going to be the lesser of, it'll be the 250. But let's say that you have a $250,000 fee, 5 times would be higher than a $1 million policy. So that would revert to the available amount of insurance coverage for your PL policy. So this is a standard provision I use all the time. I get about a 50-50 success rate with it. Sometimes they want to eliminate the bottom floor here. They just want to keep it to the available limits. That's fine. You can also do this sort of provision, but you say shall not exceed, and you can insert a dollar amount. You can say 500,000, 100,000, 50,000. But what I want you to understand is that amount better be sufficiently higher than the amount of your fee, or the courts won't enforce it due to public policy concerns. So instead of having my clients try to, in their head, do the estimated fee, do a multiplier, and then put a number down, we use this as a self-executing formula. Inspections versus observations, there is a difference. Be careful using the word observation, which is more general. It's usually done for periodic visits. You're not really getting up there if you were a structural engineer, for example, with a torque wrench and looking at the soldering of bolts and that kind of stuff. You're not, as an architect, you're not going through with the level you would on a punch list inspection. So be careful how you use those 2 words. Have to be consistency in your documentation. And whereas we're running out of time, I'm going to move a little bit faster. Now the ugly stuff. Watch out for owner forms meant for contractors. I see this all the time. 7, 8 out of 10 agreements I get are basically meant for contractors, and they just carry it over and they give it to an architect. It has warranty language. It has additional insureds for the insurance policy, which is not possible under professional liability, as Rich will tell you when he does his seminar. It has to adhere to the standard of care. They'll put in here highest levels of standards or world-class architect services that violates the standard of care. It's not insurable, as you can see in the 3rd bullet point. I already mentioned the additional insured for PL insurance. You never agree to defend the owner. You can't do it under the PL policy. You got to strike that. You got to narrow the indemnification. That's a whole nother topic, which unfortunately we may have run out of time for. You only want to use an indemnity that's narrow here in the second to the last bullet point. If anybody ever gives you an indemnity that doesn't look almost exactly like this, insist on these exact words in this narrow section. You cannot agree in a contract to pay for the fault of another, which is called broad form indemnification, and expect your PL carrier to pay for it. They won't do so. And be careful with the word certified, because that is synonymous to a warranty or a guarantee. And I know you're going to say, I do payment certifications and I use the G702. I get it. That is lagging behind. That was done back in 1972, that G702. So I kind of edit that on my payment apps and say, you know, I certify in the form of professional opinion, and that solves that problem. I think I may have just, yep, okay. So don't be this guy, you know, coming to me with a problem, and also be careful where you place your revision clouds on your drawings. Marvin, questions?
Yeah, we have a couple more. Let me see. I'm sorry. Josh Zinder said, I thought subrogation was not permitted in New Jersey.
Subrogation is absolutely permitted in New Jersey.
Okay. When parts of the design is delegated to a trade partner that is contracted to the general contractor or owner, can there be claims against the design professional? Sometimes in delegated design, there are gray areas of responsibility that fall through the cracks. That's from Chris Silver.
Well, good question from Chris. Could be a seminar, again, in and of itself, well beyond the basics we're talking about. But here's what I can try to shoehorn in. The AIA language, if you look at it for delegated design, I think it's in the submittal section, and it basically says the architect can rely upon the certification or signing and sealing of the contractor's delegated design professional, and has no liability. What I can tell you, the state of New Jersey will not agree. In the state of New Jersey, even if you delegate design, you are still the architect of record and responsible for what happens. You may be able to seek what we call contribution or indemnification from that delegated designer, but you are on the hook as far as New Jersey law and the State Board of Architects would say. That's, I think, the most I can do on that topic. I did do a delegated design for us as part of a submittal seminar for West Jersey AIA. So if that's something that the small firm group wants to, you know, and other topics that we talked about delve into in the future, you know, Marvin, let me know.
Absolutely, I will. And on that note, I want to thank John for the time and the effort that he put together on this presentation. It was really wonderful. We had 93 people attend today, John, which is great.
I wish we were in a room together and I could see everybody.
Well, maybe we could do that one day. Maybe we have to figure out how to make that happen.
Tell jokes. I get to tell more jokes, and we get to raise hands and have audience participation.
Well, that's great. And again, thank you. And I hope everyone enjoyed it. We will be issuing this as a PDF and as a recording available to the people that attended this, so that you can continue to note. And I do encourage you to reach out to John. He is absolutely an excellent attorney. And I think we can all look forward to hearing the other side of the coin when we talk to Rich Standing in July. So thank you very, very much for doing this. And it was a huge asset to myself, and I'm certain most people that attended the seminar.
I hope it helped. There's my information. If anybody wants to, you know, follow up with questions that we did not answer, or some of those questions which I just could not go into the detail, probably the questioner wanted, I will make every effort to respond.
Yeah, we'll leave this up for one more minute for people just to copy it down, but or take a screenshot if you'd like to do that.
And I understand you might be given the actual slide presentation to the attendees. I think that's
correct.
Thanks for having me, folks.
Thank you very much, John. We appreciate your time.
You're welcome.
Thank you.
Bye-bye. Great job, John.